All right, so 2003, Ewing v. California. The precedent set by was that it isn't cruel and unusual punishment to give someone 25 years to life for nonviolent crimes. And that's because California still has, it's called a three-strike policy. So after your third felony, they just give you 25 years. In this scenario, a man in 96 had done a robbery and a few burglaries, and those were his two prior felonies. And 4 years later, in 2000, he got busted stealing golf clubs. So this is the one that went to the Supreme Court case, by the way. This is a scenario that they thought people needed to hear on whether or not this should be legal. The man stole golf clubs. He went to the shop and he put $12,000 worth of golf clubs down his pant legs and walked out. It really happened, yeah, totally. And so it got brought to court being like, this is cruel and unusual punishment. The guy had a ridiculous crime, but because it was worth over $300 or whatever, it was seen as a felony. And the public agreed, but it's still within the state's power. The government decided that it's not cruel and unusual punishment for extended sentences. So even for posting hate comments online, they could arrest you for 20 years because that's the state's authority. Now, something argued during this case was that despite only being 6% of California's total population, Ewing's demographic made up 45% of those sentenced under the three-strike policy. And, that just shows systemic racism, that they were disproportionately affected and locked away for 25 years for committing 3 felonies. Who knows? They might have been given too harsh of sentences on the third felony.